matter of Iceland Foods Ltd and Babek International Ltd.
Mr. Babek.
Please, Lords, I'm here for the Iceland Appellant, along with Mr. Carter, I'm the junior. The Babek parties appear by Mr. Dixon. Now, first, just apologise and also express my thanks for the delayed start this morning.
No problem.
What I propose to do is I was going to take grounds 1, 2, 4, and 6, which are all interrelated. I'll deal with them all as one effectively. Although, of course, if you always have any particular points, then we'll deal with them as they arise. But my learned junior will deal with grounds 3 and 5 after I've dealt with the other grounds. So far as there is another sort of bit of housekeeping, which is Lord Justice Arnold provided the parties with a note, but with a couple of questions which we've had a chance to think about and also to agree. And so what I was going to do is to present a joint position on that.
Fine.
I could do that now, or
why not? Since you've introduced the subject.
Yes. So the first question was really: do the parties agree that since the trademark was registered in 2009, the applicable legislation is the legislation in force at that date? And the parties do agree, partly because Section 47 of the Trademark Act refers to a mark which was registered in breach of Section 3, which indicates it's also the approach in the EU IPO, which specifically deals with it in its guidelines, Part D, Section 2. Annex 1, Paragraph 1 is the full reference, which is essentially you look at the date of filing. Now, the only complication could be if you had a 1938 Act registered mark, and that's dealt with in the Act itself.
Unfortunately, we're not concerned with that.
We're not considering with it, but just for thoroughness, it is dealt with in the Act. The second question was: do the parties agree that it doesn't matter whether this is regarded as being Article 4 of the regulation or Section 1 of the Trademarks Act as it then stood? The reason for that is because it was applied for as a CTM, a community trademark, which then became termed EUTMs, and it then got cloned into a UK mark after Brexit. So, incidentally, the European mark has now been revoked, as I understand. So, Section 1 of the Trademarks Act has also gone through a bit of change. We say materially only in one respect,
well, we don't need to worry about subsequent changes. We're only, because of the answer to question 1.
it is.
If it's the Section 1, it's the Section 1 that was in force in 2009.
Yes, which required graphical representability. That is now altered to allow for more exotic kinds of marks to be registered, such as sound marks and so on, and is now capable of being registered in a clear and precise manner. So that amendment that came into the directive and act was to not only accommodate different marks, but also to accommodate the learnings of the European Court that had grown up since the original wording. So that's that.
So, but you didn't give me the agreed answer to question 2, which is it agreed that it doesn't matter?
It is agreed that it doesn't matter. Exactly.
Good, thank
Sorry,
you.
I should have said that. Right, so what I propose to do, my lords, with your permission, is to approach matters in the following way, just to try and encapsulate questions before the court, and look then at the importance of the concept of singularity of signs, the reason why such a rule exists, or the principle exists, and then to look at the need for clarity and precision, why colour raises particular difficulty. One of the things you will have noticed is a lot of these cases seem to be concerned with colour, and in doing so also touch upon the policy of the law here, and then look at the judge's errors. Now, I propose to deal with that in a sort of nutshell for probably about 30 minutes, and then I'll look in a bit more detail at the case law, just so that you know what our case is right at the outset. So, my lords, we say just dealing with the two questions before the court, or what we consider to be two broad questions before the court. The first question is this trademark specified with a sufficient degree of the certainty? And I use that expression to refer to both condition 1, condition 2, potentially even condition 3, but it's about legal certainty. And the second question is a corollary of that. What is the approach for determining when a trademark containing colour that is not a colour per se, when must it designate a colour shade, or sorry, a colour category or number?
Sorry, I wasn't keeping up with all of that. What is the approach for
It got mangled at
determining?
the end, so I didn't like my note on that, because I used the word shade. One of the things I want to make very clear is that if I inadvertently refer to shade, what I mean is hue, usually. Hue being the correct designation for colour. Now,
Could I just have that second question again?
so let me put it this way. What is the test for
Yep.
determining
Yep.
when a trademark containing colour, which is not a colour per se mark, must designate a Pantone reference?
Yes, I see.
That's the way.
Or some other
Or some other international.
recognised colour standard.
Yes, so there are others. Now, this second question arises because there are a range of factual situations. At one end, there may be a multicoloured mark, which in a very distinctive device, where colour is, there are many colours within it, and they're incidental. And at the other end of the spectrum, you may see a case like the Baby Bell case, which is essentially I'm not sure how one describes it, a flattened sphere, a cheese shape, which contains a sort of waxed coating, all in red. And the question then becomes, what must one specify the Pantone number of each hue, whether it's a multicoloured mark? So those are the
Just before we go any further, it might be useful to establish one sort of baseline, which is if we look at subject matter of the registration, it doesn't matter whether we look at it in the skeleton argument or in the register extract, which we've got in the supplementary
Yes.
bundle at tab 7. But it's common ground, as is obvious, that there are two components. There is the pictorial representation and there is the written description.
correct.
Now, would I be correct in understanding that you would have no objection if the subject matter of the registration was confined to the pictorial representation?
None whatsoever. And that's an important point which I propose to go into in a bit more detail when we come to the law, which is what is called the graphical representation, or what is called the representation of the mark, includes both the textual description and the picture. And they are to be given equal weight, and most importantly, are to be construed together. And that's important because there seems to be a little bit of a different approach, at least historically, before the EU IPO, when the position was what you see is what you get, that's the mark, and the description is sort of a chatty attempt to put in words. The other point about the description is that it's entirely optional. It's entirely a matter. I mean, for some marks you must put in some.
Well, I wondered about that. I mean, certainly that's the general position. But was that correct in 2009 in the EU system?
So in the
and I think the simplest way to express the question is this. In the UK in 2009, I think there would have been no difficulty with an application to register the picture on its own with no description. But could you have done that in EU IPO at that date?
So in our skeleton, we've extracted the implementing regulation, which are the relevant rules that applied at the time. So that's behind tab 8. We have, yes, it's page 85.
So 85 of
85 of the core bundle, first file, and tab 8.
oh, in your skeleton.
Yes. I don't think this is in, it might be.
Yeah.
But, so there are some indications of things that you need to do.
Which paragraph is covered?
So it's paragraph 41. At the date of the application for the Babek mark, then an EU mark, they were contents of applications were governed by Commission regulation. We extracted it there. If the applicant does not wish to claim any special graphic feature or colour, it's just reproduced in normal script for typing the letters if it's a word mark, and so on. And then in cases other than those in paragraph 1, the mark shall be reproduced, and then there are requirements as to quality and size. Now, in those cases, the application shall contain an indication to that effect. So you've got to indicate that it's effectively a figurative mark or a mark to which that paragraph applies. The application may contain a description of the mark. Now, then there are certain rules as to a three-dimensional mark, and there's a debate between the parties as to whether this is in effect a three-dimensional mark. We'll leave that aside for the moment. And then 5, where registration in colour is applied for, the application shall contain an indication to that effect. The colours making up the mark shall also be indicated. And the reproduction under paragraph 2 shall consist of the colour reproduction of the mark. So we take that as being, there is some information that is required to be given about the representation. If you applied, for example, for a black and white mark, and you wanted black and white to be the colours, you have to indicate that in that section.
That's because of the historical approach taken to monochrome marks.
Yes.
As being indifferent as to colour.
Now, of course, there have been important.
So the question is this: would it be acceptable? It may not matter for our purposes, but it's trying to understand the background. Would it have been acceptable for the applicant to have put in the picture, accompanied simply by a statement? We claim the mark is as shown in the colour reproduction.
The mark probably, those words would probably be okay because they simply cross-refer to the but they're entirely OTOs because, of course, not putting those words would have the effect.
Yeah, but the question is whether it would be permissible under the implementing regulation rule 3
Yes, it would be.
to put in no statement at all, and it would seem that the effect of paragraph 3 is no, you couldn't do that.
No, we would say the effect of paragraph 3 is that the description is entirely optional.
I'm
But
sorry,
the
I
indication-
should have been more precise. I meant rule 3, paragraph 5.
Yes, so 5, if you want colour to be part of the mark, then you have to indicate. Actually, it's not even that. It's where registration in colour is applied for, the application shall contain an indication to that effect, and the colours are indicated. So it isn't that you're claiming them, you're just indicating that they're there.
Well, I'm not sure a semantic debate as to the difference between claiming and indication is helpful. But in answer to my question, what you said previously, and I think you stand by this, is what could have been done is to say the mark is as shown in the colour reproduction.
Yes. And in fact, that particular statement is, or the absence of that statement, is really what characterises cases like Glaxo, which we'll come to, the Red Bull case, because very frequently, you'll see in these cases, there's a picture, and then there's a statement or description that generalises from that in some way, and that gives rise to doubt, and as a result of that, the picture only stands at best as an exemplar, one of potentially many.
Yeah, well, this is the common problem that runs throughout this, because what always goes on in these cases, and it's true not just with colour marks, but also with position marks and various other types of marks, is that the applicants who don't need to put in a written description put it in order to broaden the claim.
That's the inference. Although that's not a necessary finding, we would say. It's the objective effect of the description.
Indeed, but I mean, and that's why it's of interest, although not necessarily determinative, to try and figure out whether, to what extent, some form of written indication was obligatory.
Yeah. Well, and it never narrows for some reason. So it is a reasonable inference. Sometimes it may feel, when you're acting for the proprietors, I've done in these cases, a little bit of an unfair criticism.
I mean,
we were doing our best with the mark, but that's the effect of it.
I mean, here, the rule said the colours making up the mark shall be indicated. Now, maybe you could give your indication sufficiently by saying the colours are as shown in the colour reproduction, but one might perfectly fairly, without intending any abusive widening, think, well, I better specify some colours.
Yes, you might. I wanted to come back to that, to the choice of colours that the proprietor made when they applied for the mark in a moment, because I will be saying that there are a number of options that were open to them, and they chose this particular option, and that itself has given rise to doubt as well. But if I could just continue with the issues that relate to colours for a moment. Although it is true, as Lord Justice Arnold just mentioned, that this principle applies generally, and you've seen in the Dyson case that it applied to a transparent chamber, it applies to all manner of marks, position marks, and so on. The reason why there are so many colour cases, Nestle, Red Bull, this one, Babel, there are many others, is Glaxo, is because colour is not normally ascribed origin significance, origin identifying significance. It's usually a characteristic or property of things that many traders want to use. But on the other hand, colour may acquire origin significance, for example, being used as a livery consistently over time and so on. And there seems to be a sort of bargain, which is that the law is saying, we're prepared to give your colour origin identifying significance, but your monopoly must be very clearly delineated. Now, I'm talking about pure colour marks at the moment, but the principle is broader. If you are going to rely on something which is not normally a trademark, trademarks being generally words, signs, sometimes shapes, but the number of these sorts of exotic marks is tiny compared to the number of normal marks, then the price of that is to make sure that your monopoly is very, very clearly delineated. A second problem with colour marks is, of course, they don't have a set configuration. I'm talking about colour per se marks. They are registered per se, and therefore that presents certain difficulties. You're not configuring it in any particular way. The mark is the colour. Now, when it comes to a mark which is in colour, such as this one, it is configured in a certain way, but one has to assess the other factors that go into colour.
But why is that a problem that's unique to colours? I mean, the question is always at what level of abstraction one views the subject matter. So, if it's a word mark, the correct level of abstraction is that the subject matter is the word as a word.
Yes.
And therefore it will cover uses of the word on an identical basis, regardless of size, font, and so on, colour.
Mm-hmm. Exactly.
Because it's always the word. Likewise, as we were discussing a moment ago, if you have a device registered in monochrome, by convention, that is treated as a claim to the device as a device. And therefore size and colour don't make any difference to the question of identity. So it's a question of the level of abstraction. So if you've got a colour per se mark, then that is the level of abstraction that you're dealing with.
And in principle, it covers that configured in a potentially large number of ways, but it's not a different mark because the colour is unchanged.
Exactly.
Which requires you to specify colour. This is the Livertel case. But unique to colours are things like the subjectivity involved in human perception. When you hear the word green, the green that you think of is not likely to be exactly the same as the green that I have in mind. And people describe colours differently and respond to colours differently. They're very subjective. The other thing about colour, and the reason why you've got to have these requirements, I think is more unique to them, is that colour degrades over time. If you look at the Livertel case, one of the major considerations is that it's got to be a durable way of representing the colour, which is one of the reasons why they go for the Pantone number. It's got to be durable.
Well, I think when you say colour degrades over time, you mean printed colour.
A printed colour. But actually that brings me to the electronic transmission of colour, which of course varies tremendously according to, well, just on the printed, you can see that it varies according to your bundles that you might have got. You get good quality or less quality ones. But even when looking on your screen, it depends upon your monitor settings. And it is very difficult to ensure.
Yeah. So just to exploring that statement, I mean, as I understand the point you're making is if you take a digital photograph of a painting, just to give an example, even before you get to the question of trying to print the photograph on paper, colour representation in the digital reproduction of the painting is rarely exact.
It depends on the definition, the number of pixels, and also colour balance, white balance, white balance. So we've all edited our photos or whatever, and you see the number of settings, which completely vary the look. So all of these sort of factors that sort of suggest why the courts have been so cautious about. The final one I was going to say was colour depletion, which is an interesting concept, but it does arise. If one thinks about it, you've got rust on your gearbox is vile, was the one I remember, the mnemonic, red, orange, green, blue, yellow, indigo. You've got 7 colours, main colours. And so if you, in principle, were to allow someone to say, I can have red, well, I own red for, again, talking about colour per se, I own red for class 25 clothing or items within that class, then one can well see how the spectrum can be colonised or the number of colours depleted as a result of trademark registration. As a matter of fact, others may not be aware, there are very well-regarded US studies on the depletion of word marks, and the number of words is disappearing because everyone's monopolising them for everything under the sun. So the problem is even more huge when it comes to cost. So that's why you need to be more cautious when granting colour protection, and that's why, for example, in Livertel, there's a requirement to specify the Pantone shade, because if you let somebody have orange, then they get all oranges. Better that they at least only get a very sliver of orange, which is the one that they managed to define. going to just mention a couple of points about claims, but I think probably the next quick port of call would be the mark itself, which you can probably find that the application for the mark is probably the best copy in the papers, which you'll find in the supplemental bundle tab 6. There's a small sorry, and then the previous page, tab 5, is it? Yeah. It's in black and white, but the last page, page 23, 6, yes, you'll see a large copy. I think that's the best copy. And I'm assuming that was provided when the mark was applied in that form. Now, that's the visual representation or the picture. Then we go over the page. We can have a look at it slightly smaller.
Sorry, we can see from this that there's a box that says type of mark, which has been filled in figurative.
Yes.
And that was a standard box on the application form at that date.
Yeah.
Remind me, was it actually required by the implementing regulation?
I don't think so, because I think I've reproduced the relevant provisions, and they aren't missing anything there. But it might have been. I think Malone Junior is going to be addressing you on the type of marks. It might be good to cover that. Don't you? 2 applies. So it must be, yes, he suggested it's wrapped up in the rules that we looked at a moment ago. Rule 3.2 says, in cases other than those in paragraph 1, the mark should be reproduced. And then in 3, it says, in cases to which 2 applies, the application shall contain an indication to that effect. So maybe that's what that is, a figurative, when you put in figurative. But that's likely to have been an EU IPO form setting rather than something actually required.
Oh, it's been typed in.
Yes, yes.
It's not a drop-down menu.
Just on that, I mean, the position with figurative marks, yes, it is to be taken as a figurative mark at the starting point, but there's some case law that Junior will address you in relation to how marks to be construed. I mean, the Phillips and Remington shaver mark was, as I recall, a figurative mark, the three-headed shaver, but it was construed as one which the technical institutions like.
Yeah, well, we'll come back to that later, but just sticking with the registration
Yes.
at the moment, the statement of it being figurative is not reproduced on the UK register.
No, curiously, it's not.
Well,
The
you
description.
say curiously, but why is that curious? I mean, it's not
It's
generally
curious,
done with UK registration.
I'm just trying to think. I think there's a search parameter on the website that you can search by type of mark on the UK website. Maybe it was someone else's software or something else. Anyway, just to look at the part that I want to focus on is mark description / limitation as it's shown on the UK register, which is page 24, tab 7, and you can see that that's matched in the form, the previous page that we're looking at, colour framed, indication colours gold and black, description of the mark gold, oval with embossed writing. Now, we say that looking at that mark, the first issue that arises is that this is a picture of an object, let us say, a figurative mark. It's said to be a picture of a badge with Babek on it. It is one colour. It is gold, you would say.
So what's one colour? The picture.
So the picture.
It's not the whole shape.
Exactly.
I use the word shape deliberately.
Yes, exactly so. It is one colour with different shades. It depends what we say is this. It depends if you're taking a real world approach or if you're being a sort of graphical nerd. Right? So if you are saying, what is that? That's a picture of a badge, metallic badge, where the light seems to come from the top. So the shadow seems to be nearly at the bottom of the letters, not at the top. And that's it. It's fairly simple.
But it's not one colour. There's to me, there's yellow.
Exactly.
There's
So,
silver,
exactly. So when you look at it graphically, on the other hand, there are more than one colour, because that's what has made up the picture. So there are sort of darker bits. There's virtual whites, certainly light yellows, as well as a deeper gold. So that's the picture. And what we say, and I'll take you to some law on this in a moment. What we say is that the first problem is when it describes it as gold oval with embossed Babek writing, and then goes on to say colour claimed gold black, it seems to be wearing two hats, so to speak. It seems to be both describing it in a practical, real world way. It's a gold oval with embossed Babek writing, but then it's claiming gold and black. Now this is quite apart from the fact that it doesn't designate the other colours that are there if you're taking a sort of graphical approach. But what you've got there, we say, is an inherent contradiction between those two parts. It should, at the very least, to resolve that, we say gold and black oval, right? At least then it would be internally consistent. That's what I'm talking about, an internal consistency. The second and more fundamental problem is, on any view, we say, this is like a baby bell type case. It's a mark where the colour is an important aspect of the sign. Very, I don't know what very adds, but we say it is an essential or important element of the sign. Gold is a colour of lustre and value, and it's the only real colour of the object that's depicted, although of course with shading. And as such, we say this is a mark that falls into the category of marks that are not colour per se marks, but where colour should nonetheless be specified in accordance with an international code. Now there are other criticisms.
Well, that formulation suggests that it's not always necessary to specify the hue by reference to an international code.
Yes, and the reason for that is that I don't want to prove too much by this approach. I mean, first of all, I'm only concerned with this mark, but I recognise that I need to come up with a principled approach. But the point is that there are, if you can imagine a trademark depicting a leopard, where all the spots are different colours or something like that, it might not matter very much. Or a Damien Hirst painting, spot painting, where there are multicoloured objects in play, it might not matter very much whether it's a purple or a green as opposed to a green or a yellow, and what particular order they're in.
Well, I'm sorry, I don't understand that. I perfectly understand the proposition that we discussed earlier, that there's no need to put in a written description. You can simply put in the picture and it stands for itself, and all colours that are visible in the picture form part of the subject matter. And that's a nice, clear position. But as soon as you accept that a written description can be supplied and need not be specific as to hues by reference to standards, then how do you differentiate when a reference to a standard is required and when not?
Where The standard we would adopt, first of all, that is a perfectly clear position that we adopt, by the way, which is if you depict a representation in colour, then the colours stand for what they show. In that pink, it might be a hot pink or something. That's the pink that you own. You do, as far as the mark is concerned. You don't own other pinks. But if you do call out the colours in a description, then we say you need to specify a Pantone shade if colour is an essential element of that mark. And that is a judgment. It does involve a bit of assessment, but it's essentially a visual test. You don't look at the use, you don't look at necessarily at the goods, although perhaps it might be relevant to see how it would be depicted, maybe, but actually probably you just look at the sign itself.
Can you look at the graphical representation to answer that question? And if you do that here, it seems to me it's impossible to specify a Pantone number. And if you were to, you'd have most of the numbers that you got in your schedule, because it's by definition it's not one hue. It's shading into different, because of the light effect.
Yes.
You end up with gold that are a variety of hues. So how could you specify a Pantone number here?
Well, we've got the Pantones at the back of our skeleton, and I'm not sure if this is all of them, but in my submission, you should, in a case such as this, specify the nearest match. I mean, there are quite a lot of cases where
The nearest match to which bit of the...
well, I mean, you can sort of, I think it's pretty clear where there's not a sort of overexposure or a shadow, and you take a sort of neutral midpoint, and that's your colour. And don't forget, Pantones also come in coated and uncoated, metallic, non-metallic, and so on. So, I mean, I don't think there is any particular difficulty with coming up with that, but you could, if you wanted to. Specify
Sorry to
more.
interrupt, but you're answering a different question to the one my lord asked. So the one my lord asked is that it's not simply a question of putting in two Pantone shades. So we've got gold and we've got black in the wording.
Yes.
And so you seem to be giving an answer to the question, well, could you not specify which gold and which black?
Yes.
But my lord's point is that if you simply put in gold and a Pantone number, let's say gold palm, I'm taking one at random, 17039 0839.
On page 92, yes.
And then black, again, just taking another random one,
Yes.
1941s.
Yes.
If you just put in those two, that would still not be an accurate description of what we see in the picture, because the picture contains a multiplicity of hues.
That is so from a graphical perspective.
Well, what other perspective can one have?
Well, if one imagines this, if your trademark is a photograph of an Ocado van, right, and the livery on the outside of an Ocado van, there are a number of ways of doing that. You can do that in a very sort of a mocked up way, which is close up and very clear colours and so on, as if it's a printed graphical illustration, or you can just take a photograph of it. If you take a photograph, and that's what this looks like, it looks like a photograph, actually, or maybe a digital rendition of it with shading and so on.
It's a digital artwork.
It's a digital artwork. But in those circumstances, I mean, they raise particular issues. Yes, you do have to capture, you should be trying to capture the main colours within it, if you're relying on it as a graphical form. But I mean, as I say, there's a sort of more real-world approach, which is to say, this is a gold. A consumer looking at this has to be looked at from three perspectives: the consumer, other traders, and those maintaining the register. If you look at it, it looks like, whilst there is variation at the graphical level, if you want an extreme example of that, you can see over the page on our skeleton, page 93. You can see extreme close-up. You can see whites and dark bits and so on. So there is variation at that level, but that is probably unnecessary because a real world perception of this is to say, well, I'm going to at least designate the gold within a make a reasonable effort of.
Well, can I be clear? Are you accepting that the mark would be valid if it contained a Pantone reference for the gold but not the black?
We say because there is no black, it can't contain a Pantone reference for a black. Because there's not even a black even in close-up. It's a brown or a dark shade. It's not a black. And in fact, the judge agreed with that. There's no true black. So that's, I think your question could be reformulated as, would you accept that this would be valid if it had the sort of midpoint gold that's there plus a yellow or another one, another one of those colours that's there in the extreme close-up? I mean, it would really just, my answer to that is it would depend on what they did. I mean, as you put to me earlier, the starting point is just show the mark. You don't need to go further than that. Just show the representation. Then everybody looks at it and takes it for what it is. As soon as you introduce a description, you are embracing a difficulty, because anything you say in a description is apt to either omit information or to generalize from the representation, leading to doubt and difficulty.
So just, we've seen rule 3.5 at the time said the colours making up the mark shall also be indicated. So if someone took that to mean, well, we better put in some colours. If they want to be comprehensive, they have to list a mass of different hues, like Pantone references or otherwise. Of course, in a sense, you're no further forward because they don't tell you where they are.
Well,
So potentially you can, consistently with the description, change the position of all the colours.
gold captures most of the hues there, the word. That's not to say that that's sufficient, but it just, as a matter of wording, it captures most of it. They have come up with black, which we say is wrong. They could have put brown, yellow, white. Gold, brown, yellow, and white. I think there isn't anything in the mark that isn't one of those four things. If you were going to indicate, right, but that's just indication. That's a requirement with the rules in the UIPO. That doesn't tell you when you have to put in a Pantone shade. It doesn't tell you that because, and that's I think one of the reasons why, in answer to my Honourable Justice Arnold's question, whether we go down this second avenue at all. We do so principally for that reason, because if people are going to be using these words, that's fine in some cases and not in others. And if there is some, I assume this has been complied with. I don't know whether it, I haven't seen that many marks that actually use this language. But if it is complied with, it doesn't necessarily solve the problem, because the problem still remains: what kind of gold are we looking at? What hue?
Can I just explore it one moment longer? You mentioned, suppose you have a leopard. So you have a picture of a leopard with presumably variations in the non-black bits, and then you have the black spots.
Oh yes.
But there might be variations in the black. So suppose you wanted to comply with Rule 3 in relation to the leopard. What would you do?
Is this multicoloured leopard or just?
This is a
orange?
multicoloured leopard.
regular
This is not a
leopard.
black and white leopard. This is a multicoloured leopard with variations to an extent in the non-black spots, and possibly variations in the black spots too.
Yeah.
What do you do?
Let me just find the rule again.
It's, page 18 if you're scheduled, page 85.
discussed one alternative so far, which is you put in as shown in the representation.
Yes, and that's exactly.
Is there anything else?
Probably not. I think that's probably the easiest way. If you're going to end up listing a whole lot of things, yes, that's the easiest way. Just say as shown.
Well, at the moment, it seems to be the only way on your submission.
Yes, I mean there are various ways. If you've still got my Pantone colours there, I think there's more metallic ones in the Pantone scheme, but there's Pantone there on page 92, the metallic one, 871C, and one could say something like that with shading.
I mean, of course, in a sense, it remains ambiguous because it doesn't tell you where it is. I mean, you could keep all the same colours and swap them over.
Yes, but if you make a reference to the representation, and that is a key defect in a lot of these cases. So in Glaxo, which we'll look at, they just said as shown in the representation. Same with Red Bull. The problem is because it generalises. I mean, that shouldn't lead you to have sympathy for the applicant because they haven't done that. They're not doing that can bring down the mark. That's the point. But yes, I mean there are several ways this could be done. Trademark attorneys who generally file these things, although I think this was filed by an individual. What was it for? Yeah, I think it was actually. Trademark attorneys are specialists trained to file trademarks, and they should know what they're doing. So there are in our grounds several other issues that we take, and I'm just going to mention them very briefly because they are somewhat secondary. The big ones are the internal contradictions of black and gold, and then black not actually being in the mark. But also we mention the fact that it omits to prescribe, if one looks at it strictly, the font of the Babek writing and other elements being embossed other than the Babek writing, which are points below and in that current ground. And yes, the other parts that are embossed are, of course, the studs, the textured background, and the border, the embossed border. So, I mean, descriptions do raise problems. They're not compulsory, and they do lead into difficulty. Now, I was going to say a few words about the significance of the use of the word claimed, but I think I probably accept that although claimed indicates to the consumer, or probably to the other trader, if not the administrator of the register, that this is part of the monopoly, there isn't a great deal of difference between indicated and claimed when it's compulsory to indicate. So the judge's errors, in a nutshell, were not, and actually this might also be a brief moment to mention the standard of review. Having listened in on the proceedings last week, which involved different constituted court, but Lord Justice Arnold was part of the court, one of the questions arose, I think it was Lord Justice Jackson, who asked the appellant, what is the standard of review here? Are you just saying that the judge could have done a better job on the facts, and it's an evaluative exercise? And after a bit of consideration, she accepted that part of the appellant.
Well, to be specific, it was accepted by the appellant in that case that the applicable standard of review was that it was an evaluative decision, and therefore she had to demonstrate an error of law or principle in accordance with the principles set out in lifestyle equities and iconics.
We say that these cases are not akin to a obviousness or likelihood of confusion assessment. They are not simply matters of weighing all the factors. At least in this case, the judge made a clear error. He applied the wrong test.
That's a different question. The first question, as you rightly say, is what's the standard of review? And as I understand it, you're saying that this is not a question of evaluation, it's a right or a wrong answer.
Yes, it's binary. It's a binary right or wrong.
Well, it's the answer to the question is always binary. I mean, that's true even if it's obviousness. Is you've got to say obvious or not. But you say this is not an imprecise test. It's a precise test, and therefore it's satisfied or it's not satisfied.
Yes, we say exactly that. And we say, in fact, all of these cases have been.
How does that square with the concept of permitted variation? Because if there's permitted variation, isn't there I think you yourself said it's an exercise of judgment.
Well, there is an exercise of judgment, but permitted variation is a concept that we actually do not embrace at all. It seems to have got started from a discussion with Curly and made its way through the judgment of Joe Smith J in the Adidas case last week, considered by the Court of Appeal. The starting point is there is no permissible variation in a mark. It has to be a single mark. Sorry, just to explain that concept for the other members of the court, the discussion last week was, and indeed in Curly, which I'll take you to, was whether there can be any sort of mitigation of the principle that it be a single sign. So it's not really talking about clarity and precision so much as singularity of sign. Can you have effectively more than one sign, provided it's clearly defined? Our position on that is no, you can't. Absolutely not. We're absolutists about that. There is no support for that proposition. And indeed, in the discussion in Curly, which perhaps I'll show you the very brief passage on it, it's the authorities bundle 3, and it's tab 32, paragraph 2066, variation. Perhaps if my lord's just taken a moment to read that paragraph.
Tab what, sorry?
It's paragraph 2066 on
Tab-
page
tab.
733, tab 32.
Is this really another point about levels of abstraction? I mean, if you're dealing with something at a relatively high level of abstraction, that will encompass all sorts of variations in a sense.
Yes, it is to some extent. I haven't actually addressed you on the law yet, which I'm
No.
sure to have done. Condition 1 is that there be a single sign. Condition 2 is that it be clear and precisely represented. Condition 3 is that it be capable of distinguishing. This appears to be a sort of a softening of the first of those conditions because it would allow, it's reasonable to sort of have some sort of softening of that. It seems to be the justification. But if you just take a moment to read that, I'll make some submissions.
Which paragraph? Sorry.
Sorry, 2066 down to 2068.
Yeah, well, it's got to be a bit careful though, because the authors or the editors of Curly deal with the question of singularity of sign in a different paragraph.
But here they are saying that the degree of precision required must depend upon the mark itself. For any mark, there's a degree of permissible variation in its representation. Now, if that is true, then we would say where colour is the issue, you should be very, very careful indeed for the reasons I mentioned earlier. And then, in any event, the justification that they give for this approach is unsupported. I mean, they mention that words can appear in any font or typeface, but as Lord Justice Arnold was assessing earlier, the word isn't changing just because it appears in a different font. So the word is not changed. There's no tolerance of variation. And if you changed a letter of it, then it wouldn't be the same sign. Now, there is a possible way forward here, which is that there is a permissible variation depending on the type of mark, if the consumer would see it as the same mark and not notice the differences. And this comes from another part of the law.
Yeah, so that's the test for identity of signs propounded by the Court of Justice in the HHJ diffusion test.
Exactly so. And one could graph that.
Well, can I be clear on that? Because we had a procedural issue on that last week.
Yes.
Which is that was the test that was propounded by Thomas Brown in the High Court. The judge rejected it, and there was no respondent's notice, and so that issue was not live before us. But is it your case that the test for permissible variation is to be equated with the test of identity?
It isn't an express part of our appeal, but again, I don't want to be too more draconian, more absolute than I need to be. That is that sort of mitigation of the rule is so strict. I mean, it works for double identity. So, yeah. We do touch upon it when we talk about essential elements in our skeleton in 37, paragraph 37, page 82.
Yes, I'm sorry. That's a. Never mind about that.
Yeah.
Because the question is this: what you're addressing presently is the question of the extent to which there is any permissible variation at all, and you started by saying the answer to that was no.
Well, that's our starting point, yes.
But upon questioning, you seem to be accepting that there might be some softening of the edges. And the question then is what is the extent of the softening and what test one should apply? Now, the logic of the identity test is that the legislation always requires that you be in a position to decide whether what's on the register is identical with something else, be it another trademark or a sign that's alleged to infringe.
Yeah.
And we know that the test of identity includes things which are different if the differences would go unnoticed by the average consumer.
Yes.
And that provides a perfectly logical criterion for saying what the limits on permissible variation are, because if differences would go unnoticed upon a test of identity, then why can't you have that degree of variation?
Yes.
So there's a logic to it.
Yes,
but on the other hand, this may be one of those areas to it where the life of the law is not logic but experience, and experience might suggest that actually that's a bit narrow.
I was going to suggest just the opposite, which is experience might suggest that that's a bit broad. And the reason for that is, of course, that the way that the whole trademark system works. You must have a fixed point of reference to start with before you then get into, is this infringing sign identical? Only if the differences pass unnoticed. So you've already got a bit of mitigation. Then it goes against confusingly similar signs, and they can be just similar. And then there can be 10.3 signs, which can be not that similar. They just cause a link. And then you look at the revocation provisions, which specifically say use of a mark in a form which doesn't alter the distinctive character can be sufficient. The other problem with the LTJ diffusion or double identity rule and grafting it onto the anchor point right at the beginning of the inquiry, reason why we take an absolutist approach to start with as our principal submission is because actually the LTJ test masks a bit of a problem, which is what is the mark that you're saying is identical. A lot of the cases concerning double identity, even Arthur and Felice, the leading case, the earlier mark was Arthur, the later mark was Arthur and Felice. Well, so the Arthur element was identical, but what's the infringing sign? Is it Arthur and Felice? Was it?
But that's
Arthur?
a separate question. The question of what the sign is a separate question.
But
You
if
always
you-
have to answer that.
You do.
Even
but
if there's no doubt at all as to what the trademark is, there may be dispute as to what the sign to be compared with the trademark is.
it is, but if you import that approach, the danger is that you allow permissible variation because an element is identical, but other elements are not. And you say, well, they're not part of what we're considering. That's all. And I only say, really, the first but we would say is I've yet to see the justification, for example, an ECJ judgment or Court of Appeal judgment that says there is permissible variation. Now, it might be that this is the judgment that says that. But at the moment, the justification seems to stem from an incorrect analysis, in my submission, with respect.
Isn't it inherent in the judge's reasoning in our case? And it was certainly inherent in the judge's reasoning in last week's case.
Yes, that's
Because
right.
she accepted that there was a degree of permissible variation. And the question was what the limits were. And in that case, she held that some of the registrations were valid and others were invalid. It was a 50-50 assessment numerically because some of them, there was just too much variation.
Yes. I mean, I can see that in that case, some of the variation that seemed to be tolerated was the fact that you can't see the back of the clothing, you can only see the striped side, that sort of thing. It may depend on the type of mark, but in general, this whole permissible variation approach is something to be considered very, very circumspectly, very narrowly indeed. And yes, if it is to be adopted, then it would have to be something like the double identity test. But we go there quite reluctantly because, especially with anything involving colour, because of the difficulties of specifying colour. And we emphasise that in the trademark system, Section 1 of the Act is intended to be a fixed point of reference for a reason, because of all the loosening that takes place later on downstream.
So I think what you're talking about is and I didn't have the benefit of being there last week, so let me catch up on that. If the description here had been something like a gold oval, and it had described the predominant Pantone number within what we can see, and they'd said something like with variations caused by or the product of a visual effect of sunlight or light shining down from the top.
Yeah.
Would that be sufficient?
I think I would struggle to say that's a problem.
And yet there are all sorts of variations within that as to where the shading appears, which letter appears brighter than the others.
And for that reason, your best bet is not to put a description.
Well, I see. But does that mean because of those variations, it now fails the test of certainties?
Well, it fails because of its current wording.
No, on the wording that you first suggested the wording I.
So if I encountered that, I would struggle because it's a very real world description. It's linked to, if it said, did you add as shown in the
let's not say that, because I think that would solve the problem. But if it didn't say that, didn't specifically say as shown in the picture, but sought to describe what is in the picture in the way I set out.
I think we would say that for security, you need to say as shown in the picture. That would be the way.
So that's the only possible way the description can.
Yes, because logically, as you said, it could be otherwise the words are generalising different kinds of lighting effects that would look different and different colours and potentially shades and so on, different hues, different shades. So I think probably you would create a bit of a rod for your back in the end on that, for the reasons you give.
Okay, so that's a useful debate on permissible variation, but we've rather taken you out of your course.
That's all right. The judges, the judges.
I'm sorry, also, can I just go back to where we started this, which is the standard of review?
Standard review, yes.
Your submission is, this isn't an evaluative decision, a judgment at all. It's either right or wrong as a matter of law. It is either precise enough or not.
It is. It's not an uncertain standard. It's a very clear standard. It must be a single sign, must be clear and precise. And in none of the cases, it's interesting that these cases are almost always summary judgment, and when there's been an appeal, it hasn't been a question of the judge, made a reasonable fist of it. I'm not going to interfere.
Yeah, well, in form, this was a summary judgment application, but as a matter of reality, the judge decided the issue.
Yes. So, what did the judge do? Okay. If one takes their core bundle and turns up the judgment, six of the bundle. We don't take any issue with the discussion of the case law. He rightly covers the Glaxo case, which I'll look at a little bit more detail. Instead of a small amount of time just explaining that case. Then, but most importantly, he deals with the type of mark which I imagine we'll be addressing you on, and the scant previous case law. We had mentioned and relied upon two cases which were not covered for say marks, where the colour was not specified, and it should have been. When I say specified, no Pantone given. Now, we can pick it up at paragraph 32, page 55, because the judge decided this case as for Sainsbury's, we were invalidating the Babek mark. At first instance, the UK IPO held that it was invalid. It should have specified a Pantone shade because colour was an essential element of the mark. And that was partly because if you look at the description above, below 32, the mark is limited to the colour red. The mark consists of a three-dimensional shape and is limited to the dimensions shown above. There was an attack on the dimensions and other aspects of it. But what did for it was finally the mark is limited to the colour red. Now, His Honour Judge Hacon agreed or upheld the decision, but for different reasons given, and those reasons are set out in below 34. So, what one can see there is that rather than place importance on whether it was clearly and precisely defined, so the second position, the judge placed weight on the third condition, which to our knowledge, apart from this case, has never resulted in invalidation of a mark. But the conclusion reached was that the mark could be capable of distinguishing the cheese of the proprietor or another trader, only if that particular hue was associated with the proprietor's cheese. Those words associated, we say, imported into this concept of capable of distinguishing an assessment of distinctiveness. So
Sorry, where is the word association?
in the body of 34. And then he quotes,
Oh, I see.
and then he quotes himself in the judgment. Turning to marks containing colour which are not colour per se mark is of course the entire mark, including non-colour elements, which must be capable of distinguishing. However, the colour element may play a part in ensuring that it is, and that may in turn depend on the colour being a particular hue. So far, so good, except for
Well, yeah, but he can't mean what he appears to say in 34 because, I mean, first of all, it can't be anything to do with acquired distinctiveness because there may be an application when there's been no use at all.
Exactly.
So that can't be what he's meaning.
Well, we say that's exactly what he means. Whether acquired or inherent, it may be another way. He may be considering inherent distinctiveness. So in other words, he's looking at the sign and making an assessment of the inherent distinctiveness of it under section 3(1)(b). It's a different section which one addresses later. But actually there are parts of the judgment that do seem to suggest that he may have in mind a combination of inherent or acquired, and that the error was the one made in Zinger, which I will come back to. So it says that so as expressed as it is here, it is not objectionable depending on what he means by capable of distinguishing. So he says this in 67, it seems to me that where a mark contains colour but is not a colour per se mark, the need for precision as to hue will depend on the extent to which other elements of the mark serve to make the mark capable of distinguishing. More exactly, it will depend on the extent to which the colour of the relevant feature contributes to making the mark capable of distinguishing, and whether it is likely that only a particular hue will confer on the mark that capacity to distinguish. It will always be a question of fact and degree.
So you say this is the Paella argument
Yes.
that was roundly dismissed in
That's right. We say that. And we say, if you pick it up later, because he sort of just mentions that as an authority, but he then goes into the three conditions, and we have no quibble with these so far as they go. If you pick it up at 52, page 59, we start with the statute. I probably should have taken you to start with my thoughts. It must be a sign which is capable of being represented in the register in a manner which enables the registrar or the competent authorities of the public to determine the clear and precise subject matter, and it must be capable of distinguishing goods and services of one undertaking from those of other undertakings. So the conditions are: it must be a sign in the section 1.1, capable of being represented clearly and so on, and it must be capable of distinguishing. Now, he then deals with capable of graphic representation, mentions that it's important. The case law is a little bit out of date because this mark is old, so he's not dealing with the current version of the law. He then deals with clarity and precision of protection, again mentioning Heidelberger, Laxo, and there isn't any real difficulty with those. Then he goes to deal with capacity to distinguish, and he says that it's been the subject of, 64, of extensive judicial and academic debate for many years. The authors of Curley summarise the issues, and he gives the reference. And then he says this: the requirements of section 1.1a and b are respectively closely related. The nuances and possible alternative interpretations have not been explored by the authorities.
This sort of goes off on a wrong footing because this is the wrong version of legislation.
Correct. But given that we're accepting that they...
Well, no. Look, let's start with the correct version of section 1.1, because then we can orient ourselves
As it stood.
as it stood, because this is deeply misleading. If you don't actually look at the correct version of the legislation. So do we actually have that?
I was just wondering, I think we've got it in our note, but not for you, my lord.
My lord, I've printed off some hand-ups.
Thank
That might
you, that's very helpful. Thank you.
Paragraph 7 of your skeleton is not the right.
I think we refer to the fact that it was amended. But that is right, yes.
So it's wrong.
That is the current version of the legislation.
Yeah, so the correct version is the one that's just been handed up.
Yes.
In this act, a trademark means any sign capable of being represented graphically, which is capable of distinguishing goods or services of one undertaken from those of others. And that wording is very close indeed to Article 2 of the Directive as it then stood, and Article 4 of the regulation as it then stood.
And the current wording, as I said at the outset, was changed to accommodate new kinds of marks, but also to emphasise the court's case law and the Claimant decision, legal certainty. So this part, the judgment, is where the judge starts to say, well, the requirements of what he's saying there is clarity of precision and singularity of sign are closely related to capable of distinguishing. And he then refers to the meaning of capacity to distinguish.
Yeah, well, since we have two judgments of the Court of Justice on this topic, it's no longer open to debate.
You wouldn't have thought so, but Curley has a long section on it. I'm not going to show you the long section, I'm going to show you the summary of it.
Yes, but that's not authoritative,
Yeah.
whereas the two judgments of the Court of Justice are.
Yeah, well, the reason I was going to look at it was because, in a nutshell, my lord in Zinga and the EU IPO and what Curley calls the German theory appear to be ad idem as to the meaning of capability of distinguishing, which is that it is a background point that refers to whether that kind of sign can potentially indicate origin for any goods and services. It is not a close, rigorous study of the sign's representability or clarity and precision or singularity.
Yeah, but we know this from the two cases you cite in your skeleton argument. So there's first of all there's Postcantor, and secondly there's the Apple decision. And if there was any doubt about it after Postcantor, that has surely been resolved by Apple.
Yes.
But so the debate in Curley, which ignores Apple, despite having been published later, is wrong because it's been settled. But in itself, why does that matter?
Because the judge appeared to adopt the approach favoured by Curley. That's most clear from the fact that he incorporates Babybel, the test in Babybel, into his reasoning.
Well, that's a separate question. Because regardless of how you interpret capacity to distinguish in section 1 of the Act, the Zinga point stands. I mean, Zinga was decided at the point where we had Postcantor, and I referred to that in my judgment. But it was before Apple, and so you might have said, well, it's still debatable at that stage. But it doesn't matter because the logic is the same either way. Because what we're concerned with is the first two conditions, which have got nothing to do with capacity to distinguish, no matter how you interpret it.
That's it, indeed. And the judge, at the core of his reasoning was capacity to distinguish tells you a lot about how to interpret a singularity sign and whether it's clearly and precisely represented. Whereas we say he ought to have. So he's applied the wrong test, we say. And one can see that because he specifically incorporates Babybel in 99. I think that the observation made in that paragraph could equally be said of the trademark in this case. Incidentally, he also refers to some other marks on the register that were bandied about in Babybel, which are the Coca-Cola and Tesco marks, which is why unfairly criticised him for focusing on acquired distinctiveness. What he was saying, looking at the Coca-Cola and Tesco marks on page 65, was that the particular hue of the Coca-Cola or the Tesco marks doesn't matter. Well, it might not matter because of the dominance of the, dealing with the most well-known word mark in the world, Coca-Cola, Tesco probably the same in the UK. Of course, colour may seem, if you put Tesco in a dark red or a light red, and the Coca-Cola was in a different font or different shade or hue of red, then yes, it's going to be dominated by this household name trademark anyway. But these are not good examples, and they do seem to hinge upon the public recognition of those marks by use. Now, just to look more closely at his analysis, it's very short, and I can pick it up at 99. So
Yeah,
after
there's a more fundamental problem, which is the judge seems to place weight on the absence of any colour standards in those registrations, but it's elementary that the fact that some other registrations have been wrongly allowed onto the register doesn't show that this one is valid.
That's one of our grounds, and the learned friend will say it wasn't core to his reasoning. I mean, it's in the run-up to what is clearly the core of his reasoning, and we say it was a point that's taken into account. 100. So the reasonable reader of the registration would have understood the mark as a figurative mark as shown in the visual representation. The written description does not tell the reader much more, save that the embossed effect is of particular significance. Well, that's not all it says. It says gold oval with embossed Babek writing. And then the other issue in the judge's judgment, and I'll bring this out in the case for a moment, the lack of further information need not matter, provided there is no inconsistency. Now, what the judge never does is asks himself whether the verbal description gives room for doubt. It's not about inconsistency. If I'll show you Glaxo and Red Bull, and in those cases, the description was perfectly consistent. Indeed, in the Tom Brown case last week, I think the description was consistent. It wasn't about consistency. It's about whether it generalises from the visual representation. Of course, the way to avoid that is to say, as shown in the representation. Incidentally, in Glaxo, we did try to indicate that it was as shown in the registration, in the representation. At least we tried to indicate separately, rather than the registration itself. That was what wasn't good enough, obviously. But there is a simple fix here, and if you want to avoid generalisation and therefore doubt, you come up with a better description, or you don't do a description. So the judge's reasoning there is either incomplete or wrong, because he says the colours of the trademark are as shown in the visual representation, thereby elevating the visual representation to a position of paramountcy over the verbal description. It's not necessary for the competent authorities to be informed of their Pantone numbers, because precise hues are not important to making the trademark satisfy the seeking criteria. He says, I think in of course, with the question I was asked earlier, that the aside from that, the shading of one colour to another in the visual representation would unhelpfully require a long list of Pantone numbers. It might require more than one. It might require only a few. That again is something that can be avoided by simply not either coming up with words that capture it, capture the colours, to indicate the colours, and then indicating that it is as shown in the registration, or coming up with a reasonable list of Pantone colours. I don't know how many. I don't think it's 25 that they would need to have used. Now, he then says that the absence of Pantone numbers does not lead to the result that the trademark has multiple forms. My submission, that's clearly wrong, because that demotes the description to the visual representation. He's assuming that the visual representation is paramount. But in fact, my learned friend will address you on this, but I detected from her skeleton that she said that they do cover all hues of gold and black. That is the position, and there's nothing wrong with that. I mean, if I got that wrong, I should clarify it, as I understood it. That is a consequence that the proprietor says is justifiable. So that's, the judge doesn't think so. He thinks it's the visual representation that sort of trumps the verbal description. And then he says, for the same reason, there's no ambiguity, and cites the sequence criteria. 102, Iceland's final point, is that there are colours in the visual representation which are not strictly either gold or black. That's important because there is then a mismatch, there is an inconsistency in between the description and the visual representation, which there wasn't in Glaxo and Red Bull. So we say that that is something which is made out. He says that is true, but to my eye, the impression delivered by the visual representation is of a trademark coloured gold with shading. So he's jumped back to the real world view, having abandoned the graphical analysis of colours. So and this is quite important, because either you're going to, sorry, I unfairly said a graphical nerd, but it might just be, if one takes a strict graphical approach, one is going to list a large number of colours and hues and potentially shades as well, which don't include black. But if you take a real world approach, it's going to be, that's gold with this Pantone as shown above, with shading or lighting. Bearing in mind you don't need to say any of it other than to comply with the rules. Now let me just turn straight to Glaxo and Red Bull so that I can explain how those parts arise. Well, did you say anything about transcript writing rates? That's all I don't know. So, what I will do actually, a better starting point is the Zynga case. Because that will sort of lay the groundwork. It also mentions all the case law that was important, because most of it came out by that time. So, find that. you spear, tab 10 of bundle 1. Yeah. Well, just to look at the first instance judgment, it's just this was not a colour case. It was simply for the mark. Well, actually, no, it did have ivory.
It was ivory coloured.
It had ivory. No, that jumped out at me. Actually, I should have mentioned. I was hoping to find some learning on the colour. Yes, it was the mark is as depicted in on page.
Is it 184 of the bundle?
Yes, tab 10, page 184 of the bundle, exactly.
And I do see
And
indeed
very
see
small.
ivory coloured tile.
Yes, very small writing. The mark consisted of a three-dimensional ivory-coloured tile on the top surface of which is shown a letter of the Roman alphabet and a numeral in the range 1 to 10.
Although what is depicted is a blank type. That's by the by.
So Mr. Miller, who acted for the applicants for invalidity, had a very large number of good points, and therefore didn't take the cut point, unfortunately, as is recorded in the judgment. And he didn't take a number of other points that one just mentioned. But the issue was principally put on the basis that that description could lead to a multitude of forms which Zinger had the good grace to mock up and show the court. You can see that on page 193. All of those tiles, different sizes as well, and that's just taking the letter A and numeral 1. Obviously, you could combine a lot more than that. Now, the only point that was taken was that. If I can just pick it up from 167, this is the article of the directive. And
Sorry, pick up from where?
Sorry, 187 paragraph 10. This is the directive that the learned friend helpfully passed up the Act in the form as it was then. It was transposing this provision of the directive. And the judgment divides things into these conditions. They're sometimes called requirements or conditions. The first condition, the Siegman case, said that the list of examples of signs in Article 2 is not exhaustive. And it could be any kind of sign, provided it's capable of being, it can be represented graphically. Now, we then probably the paradigmatic case is the Livertel case. The CJU held that both a single colour, which is not spatially defined, and a combination of colours, which is not spatially delimited, are capable of being a piece of sign. But there are requirements, and they say Livertel colour per se cannot be presumed to constitute a sign. Normally, it's a property of things. Then we've got Heidelberger, which was colour combination. And interestingly, in that case, the applicant had specified an internationally recognised code number, but the configuration left a bit to be desired. The trademark applied for consists of the applicant's corporate colours, which are used in every conceivable form, in particular on packaging and labels. I think that is a case where they were potentially trying to get the broadest monopoly they could. And then, so there's some learning on that. Probably the next case to look at is Dyson, and that was where the mark was just in a picture of a vacuum cleaner, not cordless at that stage. The mark consists of a transparent bin or collection chamber forming part of the external surface of a vacuum cleaner as shown in the representation. Now, one might have thought that they'd done quite well because it says as shown in the representation, but there was a more general one, and they indicated, I understand, at the hearing that they did not intend the application to be confined to the visual
discussed in the hearing was throughout that case.
Throughout the case, right? Yeah. But I mean, it wasn't on the register. Was the point? So you'd be forgiven for thinking, what's wrong with that? We're just saying it's that transparent chamber. And essentially, the court held that that was as indicated by Dyson, it was an attempt to register a concept. And if you look at the passage indented below 20, the subject matter of a trademark must be a sign. It must confer an unfair competitive advantage.
Sorry, where are you reading from?
Sorry, paragraph 20 on page 189, and then the indented passage below there.
Which bit of the indented?
So the first one is
Well, I think the key point you want is paragraph 37 of Dyson, where they say the subject matter of the application may be capable of taking on a multitude of different appearances and is thus not specific.
It's true also, though, that these cases sometimes shade into clarity of position as well, because if you're defining it as any possible...
Yeah, but not in this case, because what they say in 39 is it's not a sign.
Yeah.
So it failed on the first condition.
That's right. It's the singularity of sign is the issue on this one. Then they move to the second condition. The judge here moves to the second condition. And that the starting point for that, and really the locus classicus, is the Sigmund case, where the CJU explained that graphic representation must enable the site to be represented visually, and they summarise a number of principles which relate to the competent authorities managing a trademark system and register, and the need for competitors to know where they stand and govern their own behaviour. And then really the sweep up is 55. In the light of the foregoing observations, sign has to be capable of being perceived visually, provided it can be represented graphically, particularly by means of images like the characters, like that. Sorry. And the representation must be, and this is the important bit, clear, precise, self-contained, easily accessible, intelligible, durable, and objective. And one can see the different those words apply sort of in different cases. In colour cases, there are issues over durability and objectivity. In other cases, where, for example, someone tries to define something by way of the smell case, where they tried to use a formula, chemical formula, whether that was easily accessible or intelligible. So they arise in different cases. But that's a pretty good list of factors that you need to apply. Then the judge goes on to deal with Livertel, which arose both under condition 1 and 2. Funnily enough, paradoxically perhaps, the use of a Pantone shade probably means nothing to the average consumer, but it's sort of, there's a quid pro quo because it gives certainty and the consumer can check. Although I looked before this hearing at seeing if I could purchase a Pantone chip card deck, and they were about £400, so I decided against it. But it might be worth investigating at some point. Intelligible, accessible to consumers apparently. And then we come to the third condition, and the analysis, I think I've got everything, this Heidelberger, which is actually, no, nothing from Heidelberger. The third condition is the capable of distinguishing, which the judge allowed. And here, as in all the cases, as Justice Arnold said, it's not necessary to discuss this in detail for the purposes of the present application. It's sufficient to note that a sign is only incapable of distinguishing the goods or services of one undertaking from those of other undertakings if it's incapable of distinguishing the former from the latter, irrespective of the goods or services in sites post-emptor. The EUIPO have given some guidance on this, and they say it doesn't arise very often, but they suggest that the word trademark might be incapable of distinguishing for any goods and services, as an example. Now, what happened in this case was, we said, very similar to the judge's approach, and It's interesting because counsel for Mattel also relied upon an older edition of Curly, but still making the same point. And the same point came up in Cadbury. And essentially it is the proof of the pudding is in the eating. People recognise Cadbury purple. Therefore, can I have my mark, please? Almost no matter how I describe it. Now the answer to that is the obvious one. No, because that's not what people are recognising. What they're recognising is a mark which you could possibly get and define properly, but not this this mark. And that's what Scrabble were Mattel were arguing. They were saying, look, everybody knows a Scrabble tile. If they see something that fits that description, they'll associate it with us. But the problem is you can't, at this stage of the analysis, get into the distinctiveness, because a mark which is imprecisely defined or constitutes a multitude of marks obviously cannot be assessed for either inherent or acquired distinctiveness. One can see that from the business end, so to speak, or the ratio of the judgment, which is up 33. The relevance of distinctiveness.
Well, you can go straight to the conclusion of 46, which is it would not assist Mattel to show the tile mark satisfies the first and second conditions to establish it has acquired a distinctive character, even if that were possible.
That's it. So we say it's not always easy to see what the judge is doing, but there's no doubt that he's emphasising capable of distinguishing. And if one looks at the Baby Bell judgment and reading that he imports, it does seem to be some concept of distinctiveness. Now, just for completeness, this was wholeheartedly, enthusiastically endorsed by the Court of Appeal, John Mummery, who says, the next tab, humorously it was described as the Paella argument. I don't know who described it as the Paella argument, if Mr. Silverley.
No, it was Mr. Miller.
It was Mr. Miller who came up with that analysis.
Yes, you can see that from paragraph
Yes.
28.
He was described as mixing everything together in one giant paella dish, which you had to taste to find out whether there was any distinctive character. But of course, even tasting it was not legitimate. You're not allowed to do that at this stage. The discussion and conclusions 31, 32, 33. I do not find his paella approach palatable. It's not a sign. It doesn't comply with graphical representability. So that's sort of the three conditions. But just to look at two cases which deal with the interplay between the verbal description and the representation. I'll look at those in chronological order. So Glaxo, which is Authorities Bundle 1, Tab 5. Unfortunately, it's not in colour. But so you can see the mark there was the picture of the Serotype inhaler on page 71.
Yeah, but we've got a colour copy of it in the judge's judgment in our case, which is called bundle page 50, tab 6.
Yes. And the description is over the page, top of second two. The trademark consists of the colour dark purple Pantone 2587C applied to a significant proportion of an inhaler, and the colour light purple Pantone 2567C applied to the remainder of the inhaler. Not a bad effort. They gave a couple of Pantone shades, and there isn't really variation, although actually, if you look closely, because this again seems to be a computer generated, you're going to see different shades. I mean, that wasn't an issue. You're going to see there's some sort of almost white there, whatever. Now, the appellant argued that the representation, what you see is what you get. It's, if not paramount, it is to be read with the description, and the description is consistent with it. So the description is not giving you incorrect information. And so the reasonable reader looking at that will say, that's the mark. There's a picture of it, and the description is there describing it. But it's true that, in a sense, demotes the description to a secondary, because it's because ultimately it is parasitic on the visual representation. Now, that was argued. The discussion is very important to the issue I mentioned before about this fixed point of reference. Lord Justice Kitchenessy then was, I could pick it up at page 86, paragraph 35. The function of the graphic representation is to define the sign so that the subject matter for which protection is sought or has been secured can be clearly and precisely identified by competent authority in the public. Moreover, and importantly, to fulfil its role as a trademark and meet the requirements of precision and clarity, it must always be perceived unambiguously and uniformly. And the reasons are plain to see. Now, the first reason given is it's got to fulfil its function as an indication of origin. It has to point to a single undertaking. Moreover, the authorities must refuse to register the sign if it's opposed by proprietors of earlier marks. So there has to be a comparison of the signs. Actually, there's a point before then, which is that, as the description mentioned, in order to assess whether it's indicating origin, you've got to assess distinctiveness. And that requires legal certainty. Then you've got to look whether the sign is similar to other signs, a comparative exercise. If it's identical, then you look at the goods and services and see if they're identical. You've got the case of double identity, which is the simplest form of infringement that you can establish. To assess confusion, you can't have a floating point of reference. So also upon opposition by the proprietor of an earlier mark, the authorities must refuse to register a sign when there is a likelihood of confusion. Then he deals with identicality. As the Advocate General Philippe Leger explained, an assessment of notions of identity and risk of confusion necessarily implies a precise knowledge of the sign, the mark in question, as they are, or as they may be seen by the public concerned. I would add to that invalidity, revocation on grounds of non-use, and the permissibility of a variant form of the sign. Really, it is probably the strictest rule in trademark, section 1. That has to be taken very, very strictly. Now, the fate of this mark is dealt with in, His Honour Judge Hacon was the first instance judge sitting as the High Court, and he invalidated the mark. The Court of Appeal agreed, and in 48 he is explaining why the description is capable of generalising to different visual forms. Because of the use of the word predominant, it was the same problem in Cadbury. So consistency is not enough if it generalises. Now then there is a discussion of the various reasons that were put forward by the appellant as to why it was hoped that a more charitable view could be taken of the description. And in fact, there was some basis for saying, well, that used to be the approach in the Office of Harmonisation of the EUIPO, and that there were guidelines, EUIPO guidelines supporting, you can see that at 64 and 65. There were guidelines supporting this paramountcy principle. This visual representation is paramount principle. But Lord Justice Kitchen did not agree because he said that there was nothing in the guidance given by the CJU that suggested that one aspect of it, of the marks representation, namely the visual representation, should be paramount. In fact, the indications were that with the description, such as in the Heidelberg case, where they tried to register 2 or more colours in every conceivable form, they came unstuck. So we tried to rely on registry practice and various other things. But that was the key point. It must be taken into account. They're of equal, not necessarily of equal weight. It's more just a question of they have to be read together. They have to be construed together. I know this point came up in the Tom Brown case. In fact, we say the 2 cases raise a very similar issue at Appellant, which is the description, verbal description, does that give room for doubt over the trademark as a whole, given that it is consistent with it, but nevertheless generalises from visual representation. Red Bull.
So which particular paragraph of the judgment is that conclusion reached in you?
Let me just.
Well, I think you want paragraph 69, which encapsulates the point that you were just making.
Yes, I therefore reject Mr. Manager's submission, yes, that paragraph, that a mark consisting of 1 or more colours is defined by the pictorial representation showing how colours are to be applied. The verbal description of such a mark is also important and must be taken into account together with the pictorial representation. The graphical representation, comprising both the pictorial representation and the verbal description, must be considered as a whole. And that's right. So if you consider them as a whole, then one can help you understand the other. The picture never says, there's nothing in the picture that indicates that's the only possible.
Yeah, and the reasoning on the case is in paragraph 80, which is when you look at it, you're in a position of uncertainty as to what the sign is. Because there's 3 different interpretations of it, and it's not clear what the right one is.
It was said to be a head scratcher.
Sorry, where are we?
That far.
That's paragraph 80 at page 97 in the run.
I've no doubt that it would not be perceived unambiguously and uniformly. It also offends against the principle of fairness, given the uncertainty as to what the subject matter of the mark actually gives tax an advantage. These deficiencies are compounded by the range of alternatives, second and third possible interpretations to encompass, and therefore pursuing the summary judgment.
Is there a sort of tension there? If you find things in the pictorial representation and in the text that could possibly be point in different directions, does that create ambiguity, or do you read them together to arrive at an overall interpretation?
My submission is it creates ambiguity. So if the in this case we've got not only generalisation by the verbal description, we've also got inconsistency in the sense of black. There's no black. It talks about black, there's no black. Maybe you could say, well, come on, it must be talking about black, but it's not. Even the judge said it's not black.
And you can't say, well, look, when I put the picture together with the text, I can see that they're talking about something that a non-specialist might call black.
Yes, something that approaches black, or yeah, exactly. So you could even go, someone would misdescribe it as black. I mean, it depends how charitable one wants to be to the applicant. And don't forget, with a trademark, so with a patent, you've got to come up with some new technology. It's not obvious. And a copyright, you have to have created it and exercised the author's intellectual creation. A trademark is a design your own monopoly. You decide every word of it. You can use the pick list of goods and services that are in the legislation or not. You can decide the timing of it. You don't have to show use of it for 5 years. So It is very much in the choice of the applicant as to what is put there. And it doesn't have to match your business at all. In fact, frequently trademarks are applied for in advance of launch for that to protect launch when it happens. So Red Bull is the second bundle of authorities, tab 19. And this was available only as a general court decision to Lord Justice Kitchen. Did deal with it, it's probably worth looking straight at the ECJ appeal on quality. Tab 19. And just to show you the marks, if you turn to page 362,
Again, this is more chrome, not colour.
yes, and I don't think we've got this, but if you've ever seen a can of Red Bull, it's a sort of shiny silver and a blue, some sort, blue, and it's the description is protection is claimed for the colours blue, recognised colour code, and silver, recognised colour code. The ratio of the colours is approximately 50-50. And again, so you could say, well, okay, I mean, if you've got out your RAL reference code book, you'd probably say, okay, those are the colours, they match. And yes, that swatch of colour above is about 50-50 exactly, or about 50%. So there is consistency on its face. But again, the problem is generalisation. And this was the Court of Justice basically holding it along the lines of Glaxo, that if the verbal description is to be given proper import, then if you pick it up at 36, it's regarded the first part of the second round of appeal. Sign may be registered with a mark only if the applicant provides a graphic representation. Where at 37, where an application is accompanied by a verbal description, that description must serve to clarify the subject matter and scope of the protection sought under the trademark law, and such a description cannot be inconsistent with the graphic representation, I've just said it's not, or give rise as to doubts as to the subject matter and scope of that graphic representation. And that is really what we're talking about here, although we also have a bit of inconsistency, perhaps the bigger point, because it gives rise to doubt in general as well. And they say why over the page at 366, paragraph 40. The two signs in respect of the protection is sought are reproduced graphically, each having an equal surface, one of blue and other. So they confirm that it was about 50-50. Those graphic representations were also accompanied by two descriptions, the first indicating that the ratio was approximately 50-50, and the second indicating that the two colours were juxtaposed and would be applied in equal proportion. So they were trying to see what they could get to be as broad as possible. And in 89 of the judgment, the appeal, the General Court found that the mere indication of the ratio of the two colours, blue and silver, allowed for the arrangement of those colours in numerous different combinations, and therefore did not constitute a systematic arrangement. So they looked at the visual. You could say, well, that's actually demoting the visual, but it is not. What it is doing is it's giving the visual context as an exemplar of the textual. And they reject the appeal.
I mean, was the visual then given any significance? I mean, if the theory is that the colours can be arranged in numerous different combinations, that seems to be just following the verbal description and ignoring the picture.
Yes, you could say it's sort of airbrushing out the picture. The thing is, the picture is there, it must be given proper account. It doesn't move the dial though, because it's just an example of what is in the text. If you have to give both of them scope, the point I made before is that the picture doesn't limit the wording. If it did in some way, then, for example, if it's sort of, it's very difficult example, it could be that the text describes some particular shape in words, and the picture actually shows that shape vividly. But the fact is, they've got to be interpreted together.
And it does denote the picture too, as you put it, a mere example, as
To
opposed
that extent it
as
does.
opposed to the sign being
Yeah.
sold.
I mean, that was what I argued against. That's not fair. It's not fair on the pictures. But
Yes, but one's got to be a bit careful about it, because in some cases it is the applicant or registrant's own case that it's an example.
Yeah.
So 2 examples of that. Dyson, the
yes.
whole point about Dyson was it was Dyson's own case, that what you saw in the pictures was merely an exemplar.
Yes.
Likewise, Tom Brown, it was Adisas's own case that what was shown in the pictures was merely an example.
Exactly, and I think in this case, you can see by the fact that there were 2 applications, one trying a bit of text in this way, and one trying text in the other way, that there was at least some attempt to see what they can get on the register.
Well, it was the same case, because although it's not spelled out, it's perfectly clear that Red Bull were not intended to confine themselves to a square divided into 2. On the
If
contrary,
you look at their
the
livery,
square divided into 2 was merely an example.
and in fact on the can, I don't think it even is vertical. I think it might be diagonal, right?
Well, you never see a square divided into 2.
Yeah. So I guess that it is deliberate. It's certainly an inference in all these cases that the adoption of general wording is
It's to
tells-
broaden the scope.
Yes,
That's the whole point of doing it.
and there's nothing necessarily wrong with that if you get away with it. Get away with it in the sense of legitimately get away with it. There are broad monopolies on the. And one can very well see with a lot of these cases that with an adjustment of the wording or no description, the problem goes away.
I mean, certainly if you ignore the square split into 2 as represented, then one can absolutely see that the verbal description encompasses all sorts of things.
Yeah. I mean, one wonders why it's done, because if you're Red Bull, you could register that square without any description. Whether you need to do a Pantone check, that's another issue. It's interesting that these are not colour per se.
They don't want to be limited
They don't
to
want to
that
be-
scope.
you don't
They
want
want a broader scope. That's why they do it.
They've got to get something on the register, I suppose. Anyway, so that is the state of the law, we say, and it's applicable to this case, and it renders this mark in breach of condition 1 and condition 2, we say, the reasons given, and just check I wasn't going to say more about capacity to distinguish unless you wanted me to. There is learning in the Max Planck guidelines and in the
It's not very helpful.
long
What's more helpful is April, and you quoted the relevant passage in your skeleton.
the abstract. In that case, I may then hand over to my
Mr. Carter.
I was going to address you as briefly as I can on 2 issues we've decided are sufficiently discrete,
Yes.
namely grounds 3 and 5. By ground 3, we address specifically the issue of categorisation and what difference it makes. The fact that we've already gone and looked at the CTM application as it was filed and seen that the applicant appears to have typed the word figurative into the box there. Now, but what is the effect, if anything, of that and the disjunct suggested the disjunct between that and the wording of the description, including the wording colour claimed. We say this goes to condition 2, clarity, precision, and also potentially condition 1. Properly considered, is this mark a figurative one, or a 3D one, or perhaps even a colour one? The combination of the pictorial representation, the categorisation, and the description, we say, renders this unclear. We've discussed.
Yes, can we come back to the issue in a way with Mr. Malinich? Because I have a problem with this whole aspect of the case, because we are now concerned with a UK mark. Yes, it originated as a community registration, but it was, as Mr. Malinich aptly put it, cloned onto the UK register. When you look at the UK register, there is not a word about it being figurative. So how does the question arise?
Well, my lord, we say, if anything, that should be supportive of our case, because the primary thing suggesting it's figurative is that word figurative, which appears in the application, and my understanding is used to appear on the EUTM register. My lord, in my submission, the wording figurative appearing in categorisation remains of some relevance in that you're required to consider whether it was registered in breach of section 3 and thereby section 1.1, and therefore we look at the position as at the time the mark was registered. We say, my lord, essentially that the word figurative suggests it was figurative. The picture, perhaps at first glance, looks like a picture, although it could just as well, we say it's ambiguous, it could just as well be construed as a 2D representation of a 3D object, of one 2D representation of a 3D object. The description, in particular its inclusion of the word embossed, strongly, in my submission, suggests that this is a 3D object, and therefore that the pictorial representation is a 2D representation of that 3D object. And then we say the choice of wording colour claimed rather than indicated. Again, all the applicant was required to do was indicate the colour. And when you look back at that CTM application, you can see in the same way that the applicant has typed the word figurative, it wasn't a drop-down menu. They've also, in response to the question colour, rather than saying yes or something, they've chosen to type the word claimed. Now, we say that essentially that leaves the viewer of this mark, whether that be competent authorities, the public, or other economic operators, we say that leaves them scratching their heads. It's precisely the mischief identified in Glaxo.
So what does the reasonable consumer or the authority think that's being claimed by the words colour claimed gold black? What are they? What sort of mark? What's the confusion there?
The confusion there, in my submission, is that suggests that what is being that this is either it's perhaps suggested that this is that the applicant views this as a colour per se mark, or at the very least that the applicant views this as approaching a colour per se mark.
Does that mean that if it's a colour per se mark, the picture is entirely irrelevant? They want to use this colour on anything?
Quite possibly, my lord. Perhaps it would be helpful if I could take you to the authority which we say is most squarely on this point. I'm sensitive of the time, so I'm trying to move through this fairly swiftly. Half-Wall, which is in Appeal, the Authorities Bundle 1, tab 7, page 135. In fact, perhaps it's useful, let's get through the Attorney General's. Perhaps it's useful to start at page 131.
And again, this is a monochrome reproduction of something that is actually blue and grey.
Yes.
And you need to look at the description, which is at page 8. sorry, paragraph 8, the previous page, 130.
Yes. Description, the colours of the sign are blue and grey, the market issue.
With codes.
And above that, you'll see that HUT will sort to register this as a colour mark. And then at paragraph 10 on page 131, HUT will clarify that it was applying for registration of the mark at issue as a colour mark, not a figurative mark.
What does that mean?
That means what they were seeking to claim is the colours per se. They wanted to claim, I would read the description as requiring the combination of the colours blue, PMS 2748, PMS cyan,
In other
grey.
words,
So you
in
can
other words,
ignore the picture.
well, the picture is a mere example.
The picture is a mere
So
example.
any combination of those colours.
Precisely.
Yes, I see.
That is how
That is quite wide.
On any object.
that would be what a colour claim would be.
Yeah.
And the key conclusory paragraph is then at paragraph 40, page 135. That's finding that where the trademark application contains an inconsistency between the sign, protection in respect of which is sought in the form of a drawing, and the classification given to the mark by the applicant, the consequence of which is that it's impossible to determine exactly the subject matter and scope of protection sought, the competent authority must refuse registration on account of lack of comparative precision. And we say, one thing that shows you, my lords, is that the court has shown itself willing to look through the categorisation as ascribed or asserted by the applicant, if one is indeed provided a tool, and to try to look at what the substance of the application
Well, surely it's the other way around, because as one sees in paragraph 41, the problem was that the sign in respect of which protection is sought is represented by a figurative drawing, whereas the verbal description related to protection concerning the two colours alone, and that's what Caldwell confirmed. And in 42, they say there's an inconsistency.
Yes, my lord, there was an inconsistency there.
Isn't then the position the other way round here? I mean, if you simply had the colour claimed without more, then that might be a colour per se claim. But when you add in not only the picture, but it says figurative, it can't be so construed, can it?
We say the graphical representation as a whole comprises the pictorial representation and the description, and also the wording where colours are claimed. That essentially forms part of the description. The word colour claimed.
Do you suggest that anybody could have understood this as simply claiming the colours and treating the picture as just illustrative?
What I say, my lord, is that the reasonable reader, whoever they may be, public, economic operators, competent authorities, of this is pulled in multiple conflicting directions. One bit, if they're looking at the categorisation written on the application, that says figurative. The picture might also, so that pulls them in one direction. That tells them it's a 2D mark. If they instead look at the verbal description, the word embossed, that tells them it's a 3D mark. And I say that the wording colour claimed, gold, black, tells them, or is at least suggested, that this might be a colour per se mark. The picture, divorced from everything else, is at least consistent with the mark being 2D or 3D. But we say inconsistent with it being colour per se. And we say the word embossed is inconsistent with it being 2D, which the categorisation told us it was. So that's why I say that the reasonable reader is being pulled in multiple different directions at once and will be left scratching their heads. It's a puzzle to work out what the precise subject matter of the protection actually is. I may not need to say much more than that. Just to briefly address you on the word embossed. I mean, as as soon as an item is embossed, it exists in 3 dimensions. You need 2 dimensions to create a flat plane, which can then be embossed into 3D. If you take a flat sheet of metal and whack it with a hammer or pass it between positively and negatively formed imprinting rollers, it will deform into 3 dimensions. I'd also note that the respondent has described the areas it calls black in this mark, shadows. That is again suggestive that this might be a 3D object.
Sorry, no.
The word shadow
it's not in the
shadow doesn't feature
No.
in the representation of the mark on the register, but in my submission, the respondent has told you that that's how these should be construed, and it ties in with the point my leader was making earlier, that if this is a 3D object, then there is no actual black in it. It's just an oval made of, let's say, gold metal of one colour looked at under ideal lighting situation. There is no black. There's just some shadow in it, and that would be suggestive of it being 3D. But if it's 2D, then this isn't shadow. It's also not black, and white and yellow and brown not mentioned, and so on. And then on the colour claim language, I think I may not need to take you there, but you've already seen, my lords, that there was no requirement to claim colour under the implementing regulation at the time, merely to indicate that it was applied for in colour, and if so, indicate those colours. In fact, my lords, the phone's for you at tab 17 of Appeal Bundle 1, page 336, suggests, let me take you to paragraph 49. The logo, again, unfortunately, this logo actually was shown on the register in black and white. It can be seen.
sorry, well, I've got lost. Which page are you on?
Page 325.
Oh, 325.
The logo.
Yeah.
That actually, because it was so old, that actually was filed in black and white. And the IPO was then told that this was a colour mark by the wording below, and that formed part of the subject matter of dispute in this case. If we then click on to 335, paragraph 49, the description, the mark is limited to colours red, white and blue. That is essentially what told us that it was in colour at all. And then at paragraph 51, Alan James, for the registrar, intervened with a letter to inform the court as to registry practice. And you'll see that standard practice appears, in fact, to have been to use the word, the mark is limited to the colours. And indeed, that various registry guidance was issued on that issue. And then working through the decision at paragraph 62, you'll see the two conflicting submissions as to how this should be construed. Miss Lane's submission was that even that language of limited to those colours amounted to a positive restriction of the rights. So in my submission here, where the language used is not that what appears to have been standard practice limited, but was the applicant chose to use the word claimed, if anything, that is even more suggestive that what the applicant respondent was trying to do there is positively assert, define, scope for its monopoly as gold black. It is suggestive of this being a colour mark, or at the very least, colour being an essential element which has been specified. Turning to look at what the judge actually did. If we start at paragraph 50, you'll see there's a finding that reliant on part law, that there's no rule of law that categorisation is provided in firm staff. But if you look at the second half of paragraph 50, we say that in fact he did essentially take the fact that the trademark applicant had written figurative as determinative of the issue, and he then used that wrongly to reconcile the inconsistencies with the other aspects of the graphical representation as a whole, and essentially gave precedence to the categorisation, wrongly gave precedence to the categorisation, and used that to resolve ambiguities, rather than finding that the ambiguities resulted in the mark being invalid. And I say that from the second half of 50. So in the first half of 50, he recognises that it's not a fixed article. In the second half, he says it's an unambiguous statement about the protection sought. The visual representation of that description may or may not be. And then at paragraph 73, the competent authorities at the filing date were told prior to intended it to be a figurative mark, clarity and precision must be assessed accordingly. And that's perhaps a slightly ambiguous statement, but we say that the use of the word accordingly there is suggestive that he's taken it as firm. And then at paragraph 83, the statement of type of mark is a useful starting point. The statement was not ambiguous. We were told it's a figurative mark. There's a focus here on categorisation solus as a preliminary issue, essentially. There's no attempt to reconcile that with a different description suggested by the description. Then at paragraph 84, he says there's no inconsistency between the statement and visual representation. That's, he says, accordingly, the visual representation could be and would have been understood to show that a 2D mark with 3D visual effects. My leader addressed you on sort of narrow inconsistency versus generalising. And in my submission again, although there's no narrow inconsistency between saying it's figurative, the figurative mark perhaps the pictorial representation perhaps generalises in that it could be construed as 2D or 3D. And then key paragraph 85, when he finally looks at the written description is not inconsistent with this either. Embossed Babek writing would have been understood to mean it's representative of embossed appearance. There's a disjunct here between the categorisation and the description, specifically between being told this is figurative, but also being told that it's an embossed oval. This is inconsistency in the broader, generalising sort of sense that was found to be sufficient for a finding of invalidity in Dyson and Glaxo and numerous other cases. At the very least, if you don't call it inconsistency, you call it ambiguity. But that in itself is fatal.
And do you now need to move to paragraph 5 quickly? We've gone past 1 o'clock.
If I might, my lords, can I address that in 5 minutes?
Yes, I
We'll
think
go
so.
back to paragraph 5.
Sorry, 5 minutes at 2 o'clock or 5 minutes now?
I could do it in 5 minutes. I'm happy either way, my lords.
No, yeah, I think now would be
No.
best, please.
In that case, my lords, on ground 5, this ground is really supportive of the others. We say one of the preliminary errors motivating the judge's ultimate application of the incorrect test was that he wrongly took into account things he should not have done. So there are two things there. The first is the effect of the decision here, of the finding of invalidity here on other marks on the register, including in particular the Tesco and Coca-Cola ones that we seem to have in mind. And secondly, perhaps more strictly, we say even the existence of other marks on the register which weren't properly in evidence before. it's uncontroversial that taking matters into account which should not have been taken into account constitutes an appealable error. This is not just a Hollington or Rogers and Hoyle issue. I think I can summarise the Rogers and Hoyle point by saying essentially that the judge must decide the case for himself on the evidence that he receives. And the point we make is that the judge in this case had regard to, if we work through the judgment, you see at 95 and 96 the Tesco and Coca-Cola examples. And at paragraph 95 he also records Council Sainsbury's submission of vast swathes of marks in the UK registry would become vulnerable to a declaration of invalidity if the mark in that case was found to be invalid. But you also see in paragraph 95 that there, copies of the registrations of a very large number of trademarks were filed in evidence. That was not the case here. The Coca-Cola and Sainsbury's marks were not in evidence here. The judge adopted findings as to their existence on the register from the Sainsbury's judgment, which, in my submission, contravenes Hollington and Hewthorne. But perhaps the more significant error really is the way in which the judge considered the effect on other marks on the register. So if we look now at paragraph 103 of the judgment, you can see that the judge was essentially adopting the submission made in Sainsbury's about what's the effect on other marks on the register. Because at paragraph 103, we say perhaps the key conclusion of the paragraph. He says, arriving at the conclusion that verbal description is inconsistent would need an assumed degree of pedantry, which would make the trademark system unworkable. The claim here, we say that the judge's decision to apply the wrong capacity to distinguish test was motivated by the effect on other marks on the register. And then at paragraph 100, you can also see him considering the effect on the register. This is the shading of one colour to another would unhelpfully require a long list of Pantone at this point. Of course, there is another solution. Either don't use claimed language, and if you do, or say as shown in the pictorial representation, if you do use claimed language, be prepared to be specific about hue. The key point we make under this ground 5 is in both these paragraphs, the judge had regard to matters which he had not have done, motivating him to apply the wrong test. Even if registry practice notes did suggest that one particular course of action, that has no legal force, and it's happened before that they have been found to cause problems with validity. For example, there's a former OHIM presidential communication that class headings covers all. That was proved to be wrong in the IP translator CJU decision. Use of the word predominant, such as in Cadbury, the Cadbury's decisions, when you look at tab 15, page 294, paragraphs 42, sub 2, and then 47 and 64. I don't think we need to take you to them now, but you can see that there was IPO guidance there saying the word predominant was likely to be okay. It wasn't. Series marks, Comic Enterprises, settled before eventually reaching the Supreme Court, but there's also raised issues. And I've already addressed your laws on phones for you and the registry guidance there about using the language of limitation. Here in my submission, using that word colour claimed was not even suggested by the guidance. So in fact, it's likely that if you find that language to be problematic, its effect on we say this is formally irrelevant, but in fact the French view suggests that the issue would go the other way in any event. You've
done that very economically. Thank you very much. We'll come back at 2.
Proviso table.